listen to speak.
Yeah, that's me. I will switch off the camera to free up the bandwidth. Colleagues, you are welcome to this briefing session today, which is a very important one, to announce the energy regulators' decisions on the market operator license application by the National Transmission Company South Africa, NTCSA, the grid capacity allocation rules, and the formation or establishment of the Electricity Market Advisory Forum. I would like to welcome our panel members, the chairperson of Nersa, Mr. Tembani Pugula, the regulator member responsible for electricity regulation, Ms. Nomfundo Maseti. Thanks, Ms. Maseti, for showing the face. And the Chief Executive Officer of Nersa, Advocate Nomalanga Sitole. CEO, if you can also show up your face, if possible.
For my people at home.
Hey, can you see my camera is on?
Yes. We can see your face. Thanks, CEO.
Thank you.
Thank you. And Mr. Pugula, if you can also just show up your face. Mr. Pugula, if possible, if you can show up your face. Okay, no, it's fine. I think when he's ready, you will.
I've switched on my camera, Charles, so I'm not sure why it's not showing on your side.
Oh yes, yeah, no, we can see you now. We can see you, Mr. Pugula. Thanks. Can see you now. Thanks a lot. We also extend our gratitude to the other Nersa regulator members that are present, members of the media, and our valued stakeholders who are joining us both here on this platform and via our various social media platforms. Today's briefing agenda will be as follows. First, we'll have the CEO giving us an overview of Nersa's mandate. Following that, the chair. Can we please mute ourselves, Chris? Yes, the CEO will provide an overview of Nersa's mandate. Following that, the chairperson will give a high-level summary of the decisions, and then Ms. Maseti will give us a detailed presentation on the decisions made. After the presentations, we will open the floor for a question and answer session, giving you members of the media an opportunity to engage directly with the panel. Without further delay, I will now invite the CEO to outline Nersa's mandate. Over to you, CEO.
Thank you, Mr. Hlebela. I don't know if I should switch on my camera. I did, but in the interest of the bandwidth, maybe I should not do so. Is that okay with you?
Yes, it's fine.
Okay. Good afternoon, Chairperson, Ms. Maseti, energy regulator members, and members of the different media houses who have joined us for this briefing session. Mine is to outline the Nersa mandate, and I would like to limit it to the Nersa's regulatory mandate in relation to the 3 items that are relevant for today's briefing. Safe to say that Nersa is an energy regulator regulating the 3 industries, namely the electricity, pipe gas, petroleum pipeline and pipe gas industries. And there are pieces of legislation governing the said industries that Nersa follows in executing its mandate. In terms of Section 7 of ERA as amended, Nersa is empowered to issue licenses, and amongst those licenses, it includes the market operator license, which the energy regulator has approved for the NTCSA this morning to carry out the scope of work that is outlined in Section 34B of ERA. And in relation to
So there seems to be a glitch. I think they were recording.
Can you please make the CEO aware that we can?
Okay, I think I was muted. I'm not sure it tells from where, but let me just start briefly. I'll be short with the Nersa mandate. And as I've said, if this has been missed, is that Section 7 of ERA empowers the energy regulator to issue a license. And amongst those licenses, it includes a market operator license. And this license, the license application has been processed and approved by the energy regulator this morning for the NTCSA to carry out the scope of work that is highlighted in Section 34, capital B3 of ERA. And when it comes to tools for regulating the electricity industry, the ERA provides, amongst others, the issuance of rules, and this is covered in Section 35 of the said Act. And these rules are subjected to consultation with licensees and any other interested party, and hence the approval by the energy regulator of the capacity allocation rules. And with regard to issues of appointing forums, the regulator is empowered in terms of ERA. Section 5 of ERA provides for that. And it does state that the energy regulator can appoint the forum consisting of energy regulator members, employees of the energy regulator, and any other person deemed necessary to advise the regulator in general or in specific regulatory matters relating to the electricity industry. Hence, the regulator's approval of the appointment of the electricity market advisory forum members. I must say that it is important to also indicate that in arriving at the decision that the energy regulator made on the 3 items, the energy regulator did follow the required public participation process as required in terms of the promotion of Administrative Justice Act. And Chair, Program Director, I think in terms of the mandate of the energy regulator, I will stop here and hand over to you. And I believe that there will be an elaboration on each of those items in terms of how the energy regulator arrived at its decision. Thank you very much.
Thank you, CEO, for that comprehensive overview of Nersa's mandate. Now I will like to invite the Nersa chairperson, Mr. Tembani Bukula, to present the high-level announcement of the decisions. Over to you, Mr. Bukula.
Thank you, Charles, and good afternoon, fellow regulator members, members of the media, and ladies and gentlemen. I may want to switch off the camera, but if I'm still audible, I will continue. So it is really my proud privilege to welcome you today to this briefing. And as the CEO has already outlined, we are briefing you on 3 decisions that the energy regulator has made. The first one is the licensing of the market operator. The second one is the approval of the grid access rules. And the third one is the formation of the advisory forum of the energy regulator. These decisions, ladies and gentlemen, are historic. These decisions are a milestone in the journey that this country is going to be taking. And these decisions, the first building blocks for what we have been tasked to do. As a regulator, we have been tasked with exercising regular oversight, but most importantly, to facilitate the transition from the current regime to a competitive market. And the third important part in this is that we have also been given 5 years to do this. One of the critical building blocks of a competitive market is the establishment of the market operator. It is with this pride that I am announcing that the energy regulator today in this meeting of the 7th of November 2025 approved the of the market operator license to the National Transmission Company South Africa, or NTCSA. My colleague, Ms. Masetti, will go into the details in as far as the conditions that have been placed, as well as the other requirements that the National Transmission Company would be required to provide. I need to stress that there's a lot more that still needs to be done, although we have approved the license since the first phase of the construction. And as I do that, I would also like to express my very sincere appreciation to the colleagues of Nersa that have put in their effort, their time, and their energies to ensure that we approve this license within the prescribed period. The starting and the the piloting of the market operator and the running of the market within the prescribed times. And to express really my gratitude to the division that was headed by Ms. Nomfundo Masetti for their effort and work that they have done in ensuring that we now have a licensed market operator. The second decision that we have made, ladies and gentlemen, is on the grid capacity allocation rules. These rules are there to ensure that there's fair access that's guaranteed to the grid. There's certainty for investors on what grid access, what is available, and when will it be available. And this, in my view, will prevent the reversing of the grid capacity and optimize the use of the existing grid. Ladies and gentlemen, these rules would now facilitate the installation or the construction of the new generation capacity that this country so requires. The last part of the decision, ladies and gentlemen, is the establishment of the Electricity Market Advisory Forum, which is going to be used to advise the energy regulator in its process of finalizing and implementing the market-related documents and requirements. The Electricity Market Advisory Forum is an important forum that is even going to be consulted by the minister in those cases where there would be a need to exempt other activity from participating in the market. And therefore, I would like to congratulate all of the members that would be read out by Ms. Masetti for their contribution. And I do want to stress that even though we have started with this initial number of members, there is no limitation in our statute that we can't increase the number and add whatever other additional skills that would consider to be suitable or required for this purpose. And to conclude, ladies and gentlemen, before I hand over to Charles and Ms. Massetti, I want to stress that these decisions reflect a profound transformation anticipated in the electricity sector, driven by the amended Electricity Regulation Act and the establishment of a competitive electricity market over the next 5 years. The approval of the market operator license for the NTCSA is a critical milestone in implementing the market rules, and we still have to develop the market code, and that process would be as participatory as all of the other processes have been. The introduction of the competitive electricity market would foster the lowest possible production costs and ultimately deliver the lowest cost to the customers. At this point, ladies and gentlemen, I'd like to hand over back to Mr. Hlebela, who will also give over to Ms. Massetti. Thank you very much for your time and your attention.
Thank you, the chairperson of Nersa, for that clear and concise summary of the decisions. We'll now hand over to the regulator member responsible for electricity regulation, Ms. Nomfundo Massetti, to provide a detailed presentation on the decisions. Over to you, Ms. Massetti. Thank you.
Thank you very much, Charles, and thank you, Chairperson, for allowing me this opportunity to take the members of the media and everyone who has joined this platform through the decisions that we have taken. And thank you, CEO, as well, for the role that you have played today. I would like to greet also everyone that is on the call. Charles, if you can kindly assist in terms of just putting the presentation on a presentation mode so that I can clearly see. The person who's flighting,
Bob, just put it in the presentation mode.
Okay, let's see if this is going to be better. All right, I can just go to the first slide because I think this is not working for me. All right, if I can just move on in terms of the getting into a little bit of detail in terms of what the energy regulator has considered, and in the way that we applied our due diligence as the regulator, as well as just trying to look carefully at the challenges that might be there, and the complexities of ensuring that what we approve is going to work, because as we indicated, these are novel decisions. These are historic decisions that the country has made today, and they are regulatory tools that are paving a way for other critical decisions that have to be made in order for us to reach that milestone of operationalization of the South African wholesale electricity market, but also for the market operator to operate the trading platforms for power market participants to participate in the market. Right, in terms of just the content that we are going to touch on, I will touch, as indicated by the chairperson and the CEO, on 3 decisions: the market operator, the grid allocation rules, as well as the appointment of the members that will serve at this stage at the Electricity Market Advisory Forum, which we call in short the EMAF. Right. So I'd like to just focus now on the market operator decision. As you will all recall, that The act that has been put into force in January of this year, it defines the market operator as a person that is licensed to operate a trading platform for power market participants, but that a person would not own the energy that is traded in that platform. So that is the critical thing that all of us, we should depart from. Now, in terms of the jurisdiction that we have, or our powers, the powers of the Act to consider these licenses in terms of Section 4.1, and I actually don't intend to go through all of this because the CEO has already touched, and this is just going to be a repetition, but just to put the context that even for the application that was brought by NTCSA for Nersa to evaluate and grant the license, it was also brought also under Section 7, which is the section that allows the energy regulator to consider license applications. Now, in terms of the Electricity Regulation Act, there is a Section 34 that introduced the duties, powers, as well as the functions of the transmission system operator. And those functions include the operation of the market. And NTCSA has made this application, therefore, in terms of Section 35, capital letter C of the Electricity Regulations Act. So I just wanted to emphasize that that is the power that made us then to look into the application that is before us. Now, looking at the significance of the decision to approve the market operator license. As indicated earlier on by the CEO, we started the process looking at the information that was submitted by NTCSA. The minimum requirements were met in terms of the documentation that is at our disposal today, which is critical for purposes of making the decision. You will see as I go along with this presentation that today the energy regulator did not approve the conditions of license, and there are reasons for that. And also part of the reasons will be explained why, because normally we would approve a license as well as the obligations that the licensed entity must comply with. But in this case, there's a lot of things that are at stake, including the issues of ensuring that there are strong measures that are put in place in terms of the handling of the conflict of interest. Secondly, the critical independence, not just assumed independence, but from a practical point of view, that this is the independence that the market expects, so that other participants can have and potential investors can have confidence, not only with the regulator in enforcing the rules, but also with the market operator that is entrusted to ensure a competitive market and a fair market. So that for us was a critical consideration, and we did not want to take chances. And hence we said today that we will take at least 30 days to look into this, but also NTCSA has also understood the challenge and some of the complexities, and therefore it indicated that it will cooperate with the energy regulator by submitting the conflict of interest or the roadmap that will ensure that the conflict of interest is well managed, as well as the issue of independence. So those were the critical things that NTCSA was going to just make sure that it will provide to the energy regulator. Now, this market operator license that has been granted, really, it is a cornerstone of the South African electricity industry reforms. And it will also, it is expected that it will unlock the future of a competitive power sector in South Africa. The significance of this decision brings many dimensions in the electricity industry that we need to just keep in mind, and I will touch on the issue of enabling the transparency that is required in the market. And as I indicated earlier on, also the fairness in the operation of the market itself, that all the participants that are participating in the trading platforms that are handled by the market operator, that they will be given the same opportunities and the competitive opportunities to also just drive competition, improve efficiency in the way that the trading of the power is done in South Africa, and also just in terms of access to that platform, the trading platform, and we will make sure that we enforce the rules for fairness and also enforce the rules in terms of market manipulation that is manifested by way of abuse of market dominance, or if it manifests itself in terms of market power. And also the prices, obviously market power will manifest itself in terms of prices, in terms of restriction of the capacity or output that is there, whilst the prices will later on rise. So those are some of the things that we'll look at. So just looking again, just on the license conditions, I'm not going to spend time on this. These are just the principles that we are looking at a high level. We've got the draft of a detailed license conditions, and what is going to happen with the draft that we have is indicated earlier on. The energy regulator did not approve at the moment. It just noted those license conditions, and I've already outlined the reasons why license conditions had to be noted today and not approved. And what we are going to do with the license conditions, we will also just send them to the market operator just to have a look at them, and then we will they will then comment on what they want to comment, but also address the concerns that we have indicated to them, concerns that will enable the regulator to make sure that the independence that is expected, it will be seen and it will not be assumed. And so there is a number of issues that we will have to look at, including the IT system, including issues of disclosure, including issues where, for instance, you could have a situation where information that has to come to the market, then it gets provided first to maybe to the board of the I would say the market operator in inverted commas at the moment, but I mean NTCSA. So we need to look carefully at those things. If, for instance, we expect the market code, should the market code be given to Eskom Holdings board before it is submitted to Nersa? What will that do then to the party that will then have undue access or information with regards to what the market code is going to be? I'm just making an example of a market code, but it may be something that is critical for the market, and therefore it goes to that parent company, which is Eskom's holding, maybe, and also the board. And is that something that we want to do? Obviously not. So we need to see how are we going to deal with such instances should they happen. And you will appreciate that it is not easy to monitor conduct and things that you might actually not see, but it is something that we need to craft carefully in the license conditions and see if some of them will make reference to the market rules so that Nersa is able to enforce its powers through the market rules. I would like to stop here when it comes to the market operator, but just in summary, as a key takeaway, the issue is that we only approved the granting of the license to operate the market, and that is granted to NTCSA. But when it comes to the conditions of license, we have 30 days within which the energy regulator will scrutinize and make a decision. Same with the reasons for decision. They were before the board today. They are quite detailed, and our meetings are open to the public. They may have followed what the issues were raised during that time, but they will also be approved together with the conditions of license. I now turn to the second critical decision that was taken by the energy regulator, which is in terms of the grid capacity allocation rules. This milestone is very important, again, within the context of ensuring fairness and avoiding instances of undue discrimination in the market itself. As we know, that capacity is quite, the grid access is quite critical for everyone to be able to enter the market and participate in the market fairly. Now, the rules that must be put in place are the rules that must be fair and applicable to everyone and be enforced in the same way that they will be enforced to parties that are interrelated parties or affiliated parties. So there should not be a treatment that seems to be favorable to interrelated parties. Now, why the need to change? Grid connection capacity in South Africa is indicated. It is a highly contested space because everyone wants to enter the market. We also want to drive investment. That is one of our functions as a regulator, to make sure that we facilitate investments. Now, we want to make sure that when we regulate, at least there are two also critical things. We must be an effective regulator. Whether or not we have the necessary legal and regulatory tools in place for us to be able to regulate in an effective and efficient manner, it is something that will always bring up to the extent that we're not able to do what we would like to do, seeing the outcomes of the market that we are supposed to create, as the law requires us to assist this market to transition to a competitive power trading market or electricity market. The challenges with the previous system, the old first come, first serve approach, and we're just touching on a few things that we had to just say apply our minds on. In terms of what was in place, and which is something that was used by the incumbent, not necessarily something that we developed ourselves, was the fact that it allowed speculators to reserve capacity without progress to that. So this is something that we must guard against in terms of the rules that we have approved, creating inefficiencies. And for that, actually, what it will do, it will, if we were to allow such a thing, it would actually be tantamount to abuse or exploitation of market power, especially because we are dealing with a natural monopoly. So access becomes compulsory. So that is the defining point for us. And once then we have, as a country, recognized the issue of the natural monopoly and the market power that exists. Now, what we need to look at is the abuse of that market power. It is not illegal to have the market power or to have dominance. What will be illegal is the exploitation or the abuse of the market power or market dominance. Now, if then that is exercised in any way that seeks to exclude others from gaining access when they qualify to gain access, we will then have the opportunity as the regulator to exercise our powers of intervening in such instances. So I just wanted to explain that part. In terms of the approval, the regulatory approval, the rules were approved on 12 November 2025, just to ensure reliable grid and support to the South African energy transition. And the transition, I think this is key because this is what the Act says, not just the energy transition. The Act stipulates our role of ensuring transition to a competitive electricity market. They align with Objective 2 of the Electricity Regulation Act to promote sustainable infrastructure and as well as development. But we also want to make sure that when we regulate and when the market is being operated, it will give confidence to investors. And in the way that we give effect to our mandate, we must always keep in mind that we will also facilitate investments into the market. So the grid code capacity does guarantee that transparency as well as fairness and non-discriminatory access to the limited grid. It also seeks in some of these its provisions to prevent inactive projects from reserving capacity and only and ensuring that there is going to be credible and ready to connect projects. And those things are things that were raised during the public hearings and what it means, for instance, to say the project is ready and yet it is not ready, and also the powers to ensure revocation and how we are going to deal with those things. So without wasting time, also these are things that we're going to start with, but also the one other thing that I would like to start on to mention here, which is also critical. Even in other countries, I'm talking developed and matured markets around the world, they are still grappling with the queue management. For instance, in the UK, as we speak, they are issuing the regulator. They're also issuing improvements in the way that it will handle the queuing, and what are some of the things that they can do to improve that. So these are also things that we must remember. That IT, can you please assist? There's some reverberation. I don't know where it comes from, but if you can mute so that we can proceed without any interruption. So the emphasis here on the issue of improving queue management is important in the sense that we will implement, but we must also bear in mind as we implement all of these regulatory instruments that every country starts somewhere. And as it starts somewhere, even when you have had these regulatory tools for quite some time, there will be a time when you need to go back to the drawing board and look at how you can sort of unlock things that things that are sort of unintended consequences that you need to deal with and address in the market. So I just wanted to put an emphasis when it comes to the queuing aspect, as we have checked with other jurisdictions. What is it that they are doing? And other jurisdictions are even improving the institutions that were established, the interface between those institutions, because they could see that what was intended for the market and the outcome of the market is not being achieved as intended. And that is because of certain things that are put in place and not because of the ineffectiveness of those bodies, but maybe the way that they are crafted in the legislation. I just want to flag that aspect, that everybody must understand that this is not going to be an easy task, but it has its own complexities, and we are going to navigate those complexities together just to make sure that we achieve what is intended by the legislation and the policy imperatives that are translated into the legal provisions that we have in the Electricity Regulation Act. Now, in terms of the background here, I just wanted to just touch on these amendments that were effected in January of this year, that they really put South Africa on a trajectory to transitioning to a competitive electricity market, as I indicated before, and also introducing something new in the law, which is the establishment of the independent transmission system operator. And that is something that will be introduced in the next 5 years. And that transition is quite critical as to how even the energy regulator is going to manage that transition, as we are granting, or as we have granted the license to NTCSA today. So during the transition, NTCSA is deemed then to be the TSO, the one that has to be established in 5 years' time. And it will engage in new licensed activities of a system operator. And that is already stated in terms of section, I think it must be section 34, capital A, and the duration of 5 years is also prescribed in terms of section 35. capital C. So what we have put here, we have put it in accordance with what the law requires us to do as we try to put all the relevant systems that will ensure that we transition the market and we introduce competition in the market as the function of the regulator. Just to again indicate the fact that now that we have approved the market operator license, what we expect now is that the market operator will submit a market code as for approval by the energy regulator, as well as the market rules that must be approved by the market by the energy regulator. And in these codes, obviously, that's where we also expect that the conduct that we expect in the market, it must be included without preempting what is going to come before us. But it is obviously something that has to deal with that. The energy regulator is expected to enforce these rules proactively and enforce them effectively. We will look at the things that might be legal risk that may actually not enable us to do as much as we would like to do. So those things are also meant to ensure transparent trading platform. There will also be issues that we have to deal with that pertain to mechanisms for legacy issues in respect of the IPPs as well as ESCOM generation as to how do we deal with such issues. One of them being the vesting contracts. How are we going to deal with the vesting contracts? We might not take what is in other countries because we're also a unique country and we have our own sort of challenges and things that we would like to see. So there are issues, for instance, that were raised during the public process regarding the duration of the vesting contracts. What is going to be the duration of the vesting contract? The second thing that was also raised that Nersa must take into consideration, just to show that we have taken those into consideration, is the issue of the legacy charges and the fixed charges that Nersa must be aware and awake when it comes to that, because if then there's a kind of a behavior that will seek to load some of the fixed charges into these vesting contracts to the disadvantage of the other market participants, it is something that the regulator may need to pay attention to. I just wanted to emphasize some of those things that we may need to take into consideration. They were mentioned, and we want to just show that we have taken them into consideration and may be dealt with in terms of the market code and in terms of the market rules. The urgent need for the regulator to adapt into its new mandate and also to capacitate itself is something that we've already started at Nersa, and also getting the expertise that are required and also the training, and it's going to be on an ongoing basis, that training need until we do what we have to do right. In terms of just the role of the regulator and the establishment of the IMAF, you will note that that decision of establishing the IMAF and the need was taken in March of this year already. So there's a number of things that the energy regulator has been doing to try and prepare the environment. So the IMAF was established in March. What we have done, we have gone through the process of now ensuring the operationalization of the IMAF. It was stated earlier on that the IMAF was established in terms of Section 5 of the Electricity Regulation Act. But if you give regard to Section 6, if I'm not mistaken, of the Electricity Regulation Act, it also gives the minister powers to make changes. But before the minister does that, the minister will do so in consultation with Nersa, plus the stakeholders, in terms of just looking maybe at the state of the market, looking at the competition the conditions and competition state of the market. If then there are changes, for instance, that may necessitate that maybe we don't need to issue licenses. If you don't issue licenses, you may need, I'm simplifying and putting an emphasis that you may need to do registration in terms of Section 9 of the Act. Then the minister will undertake a process that will ensure that there is consultation with the regulator first, as well as the stakeholders as well. You must also remember that in the Act, in Section 15, the other subsections, it does also state that where the price is determined through a competitive process, then the regulator may not need to to approve the price, and that is expected because you don't want to regulate in market segments or in instances where the market or competition is working effectively. So if competition is working effectively, there is no need for you to regulate. So it seems that the Act contemplates that situation should we be in a position to reach at that situation in certain markets. And Minister, through the IMAF as well, it may be something that Minister may seek some consultations on. So it is just by way of emphasis. So in terms of the operationalization of the IMAF, the critical decision that we have taken was to undertake a process of identifying the members that must serve and the expertise that are required to get us started and off the ground. That has been done. It was a robust process, and we also issued the calls for nomination. And we have come to a number of, I think, about 13 or 14. I must just check my notes here. In terms of IMAF, I don't have the names at this point in time, Chairperson. I'm sorry about that. You may decide if we want to put the names. Reason being that would like that there is going to be a launch of IMAF. I'm sorry to put you on the spot here, Chairperson, but there will be a launch of IMAF. Yes, there is an approval today, and also the team did not want to anticipate to preempt the decision of the energy regulator, so they then could not put the names forward until that has happened. But it is not an issue if we would like to announce the names today. So from 29 April 2025, just to give the roadmap in terms of IMAF, the 25, there was that approval. I said March, it is the 29th of April 2025, just for correction purposes. And 2 July, and there was the invitation call for nominations and following process. And then 31st July, the nominations closed, and this is just the process that was followed to get us where we are in terms of the appointment of the members, which was the decision taken today. Now, the scope of IMAF is to provide the independent advice to the energy regulator, and also just the advice on the development and approval of market rules, market code, play a critical role in terms of the market surveillance, in terms of the market investigations also that might take place where there are allegations of abuse of market power, abuse of dominance, and in what way. So those are some of the things that IMAF will play a critical role, and also just to monitoring of compliance with by the market operator, and also monitoring and provide recommendations for enforcement of the market rules and market conduct, and whatever other evidence that shows that there are certain contraventions that are occurring. But we also expect that the market operator will bring forth to the regulator, things that are happening in the market that may actually disadvantage other players because of the conduct of the licensees there. So this is just in terms of the role of IMAF. I'm not going to repeat that. This is already done. in terms of the process that we have followed, how we have followed it. In terms of the interface, it is stated there, the key institutions, that the interface with key institutions related to market readiness efforts. In terms of the public sector, the department, we worked very closely with the department and TCSA, and also the related market code, the private sector as well, through the Energy Council. We worked very closely with them and we got very good input. And these things are very important because we cannot navigate this complex path alone without recognizing what the market is expecting. And that is a critical trait from the regulator, understanding what investors want, what the market wants, and listen and make sure that what you do is not going to impede what the market needs to do. So just to go to the last point, the regulator has approved about 14 members that must serve at the IMAF, and the chairperson has already provided leadership there in terms of indicating that this is just the start. It is not that we will always have 14 members, but for now we're starting on the 14 members, and then we'll see how things go. The letters of appointment and confirmation of acceptance by the members, it will be sent. They have not been sent, which is also another reason why we were not certain whether we should be announcing who the members are. The publication of IMAF members and official launch subject to availability. There was a consideration that maybe let's do it on the 20th of December. This is so that if there are other parties that would like to work very closely with IMAF for other critical decisions that must happen in the new year, those interfaces and discussions can actually take place. So that is why we thought that before we close in this year, we should have a launch so that work starts right away. Onboarding and induction will be done up to early January. The operationalization is expected as IMAF is expected to assist in terms of reviewing the market code that we expect the market operator to submit to Nersa, as well as the market rules that will be submitted to the regulator. So by then, we expect that the IMAF would have started its job by January 2026. With that, Chairperson, I would like to thank you for the opportunity and to thank everyone who have listened to the presentation that I've made. Thank you very much. I'm handing over to you, Charles, and you may then proceed. Thank you.
Thank you, Ms. Masetti, for that detailed and informative presentation. We will now open the floor for questions. And if colleagues can kindly introduce themselves and the media outlet they are representing before asking the question. And if possible, just switch on your camera just to show your face when you introduce yourself. We'll begin with taking the first round of 5 questions. I can see how many? 3. I can't I'm not able to see the names. I think it's Carol, number 1. Number 2, Lamis, and Mr. Yelland, in that order. Over to you, Carol.
Good afternoon. Thanks, Charles. I'm Carol Payton from News 24. Could Nersa please explain, either Mr. Bukula or Ms. Masetti, you spoke about, concerns that you have in terms of the market conditions and the independence, the conflict of interest issues with the TSO and the NTCSA. What exactly are you referring to? I mean, are you referring to the fact that the TSO and NTCSA, well, NTCSA is an Eskom subsidiary and therefore not completely independent, and there could be potential conflicts of interest. What exactly are you referring to? And then secondly, with regard to the grid access rules, can you just explain, does that grid access unit, where's that located? Yeah, who administers that from here on? Thanks.
Thanks, Carol. Lamis?
Hi, everyone. I'm not sure if you can see me. Okay. Hi, I'm Lamise Heyman. I'm from CRISM. I do research on energy. I think, firstly, I just want to acknowledge what Nersa has done to approve the market operator license. I'm sure it's been a long journey. And thanks for also just outlining what's next in terms of considering the market code. There was mention on the vesting contracts, and understand the NTCSA must submit a vesting contracts framework to Nersa for consideration. Can Nersa provide an update? Has that been provided for consideration as yet? And just in terms of the wholesale tariff price process, has that at what stage is that? And the EMAF, is that a part of the interventions to kind of help capacitate Nersa to manage all these multiple changes in the market? If you can just elaborate, is that another intervention to help bulk up Nersa capacity? I know there's mention of training. Are there going to be an expansion of the team at Nersa, or is EMAF going to help plug those gaps? Thank you very much.
Thanks, Lamis. Chris?
Thank you, Charles. My name is Chris Yelland from EE Business Intelligence. I have a few questions, if I may. And the first one is, does it concern Nersa that the Eskom Holdings Board is wanting to approve the market code? And does this not pose a serious conflict of interest, as Eskom Generation will be a market participant, and it is really allowing one of the market participants to have a say in above anybody else in terms of approving the market code before it goes to Nersa. My second question is, to what extent will network service providers, that means Eskom distribution and municipal distributors, be prohibited from adding requirements for grid allocation on top of those already specified by Nersa in these rules? And specifically, does it permit Eskom and distributors to require the applicants to have secured off-takers and to provide the details of these off-takers? And if so, how would this affect the ability for the grid to be allocated to projects being developed for participation in the nascent South African wholesale electricity market, where there is no specified off-taker? And then what provision is made to require that Eskom distribution and municipal distributors separate the function of grid allocation from the conflicting functions of generating, buying, and selling electricity? And finally, is it possible for Nersa to license more than one market operator? Thank you.
Thanks, Chris. We'll move to Antoinette. Antoinette, I think you are on mute.
Thank you, Charles. Antoinette Slavert, I'm a freelance journalist writing for MoneyWeb, among others. I just want to make sure about the grid allocation. There was an issue from the IPP side that they were concerned that grid connections, for example, at the old Eskom coal-fired power stations, automatically falls back to Eskom Generation, and the argument was that should go back into the pool. I want to know how you address that in the grid allocation rules. And then, do you have a date for the start of the South African wholesale energy market yet? I think the last one I heard was in April next year. Is that still the case? And then I just want to make sure the MF, is that specifically advising on the market operator, or does it have a wider role? I might have missed that. Thank you so much.
Thanks, colleagues, for the questions. I will request the panel to respond. Ms. Bugula and Ms. Masetti and the CEO. Over to you. Thanks.
Thank you, Charles. I think if I may let Ms. Masetti start and then I'll follow.
Mr. Bugula, and thanks for the questions. I would like to start off with the question that was asked by Carol regarding the conflict of interest. Carol, yes, the reason why we are concerned is because of the interrelation that I've indicated earlier on, the fact that Eskom and NTCSA, they share the parent company, and therefore they need to be completely independent. Unfortunately, that is not going to happen. Well, I'm not saying it's not going to happen, but what I'm trying to say is that there is a concern that there may be assumed interdependence, assumed independence. What Nersa needs to do is to put in place measures that will ensure that there is practical independence. So we are concerned about that conflict of interest and how best can we make sure that it is dealt with. And that is the reason why also NTCSA has indicated to Nersa that it will provide a roadmap to present to the regulator, something that will deal, in their view, effectively with this concern. And that's why we could not approve the license conditions today, because we want to make sure that we tighten the screws when it comes to that, because of the proximity of NTCSA to Eskom, and to avoid that certain information that should benefit all parties, entities in the market, that information, the other party that is related to NTCSA is not going to get an early access to that information. So it is on that basis that we are concerned. In terms of the rules themselves, remember the rules, Nersa is required in terms of the law to develop the rules. So it is our legal mandate to develop the rules. Once we develop the rules, we must make sure that we enforce the rules, meaning that if people or their licensees do not comply with the rules, that Nersa will step in and make sure that we do what we have to punish the conduct that appears to be in conflict with what is stated in the rules. So we will administer the rules that we have established, such as the GCAR rules that we are talking about. But in terms of the conduct in the market, who's going to allocate the grid capacity that is there, it is not Nersa that is going to allocate capacity. It will be the licensee that allocates the capacity, and we know that the capacity is limited. Then if they allocate it in such a way that it is tantamount to discrimination, it is tantamount to excluding others in a constructive way, like a constructive refusal to grant access. You seem to have taken a step that promises that you will grant, but you do other things that then are against that granting of the license. Then we will then look at it as to whether this is tantamount to a constructive refusal to grant, or is a constructive refusal or discrimination to exclude others. So it will be Nersa's role to do so. In terms of the vesting contracts that were asked, the vesting contracts that we are referring to are the legacy contracts that are already in place. What we are talking about there is the fact that there are contracts that are in place, but now, obviously, we can't do away with those contracts overnight because there are certain obligations that are there, and we don't want to disadvantage the parties that are part of those contracts. Now, also, we are mindful of the impact of such contracts to the fair and competitive market, to the extent that such contracts that are in existence could give undue advantage to the parties that are part of that contract. Now, how do you mitigate that? How do you make sure that you will balance the interest of those that are likely to be affected in an adverse way by the vesting contracts, but also for those that must make sure that contracts are respected? How do you do that? So that's why the concerns came up from the stakeholders about their recognition. First of all, they recognize the importance of transitioning. Now, the issue was, for how long are you going to have the vesting contracts so that you can mitigate any adverse effect on the market? So that's the issue that the regulator must apply its mind on. Should it be 5 years, as others have proposed, or should it be longer than 5 years, as others, as those that are involved in the contract have said? We don't think that it should be 5 years, perhaps it should be more, and we have a choice of not participating in the market should it not suit our interest or commercial interest. So we need to look carefully at that and look at whether there exist any other economic reasons that would require us to look at 5 years or more than 5 years, but we'll come up with some framework that could guide Nersa, and we will invite the stakeholders to also come in so that we all come up with solutions that will work for the market. With regards to IMAF, as we indicated, it's an advisory forum, and Nersa is required to establish such forums to get any necessary expertise that exists out there. There is an example that the chairperson has made earlier on when he is actually the person that led the introduction of renewables in the country at the time when it started as the regulator, and also the issues of prices that were a concern at that stage. But Nersa at the time played its role, and in doing so, even on issues of what's going to happen in terms of the, managing the voltage and all of those things, if we introduce renewables, he guided that process. And in the way of guiding that process and to capacitate the energy regulator and also give confidence to the parties in the market, he then established it through the decision of the regulator, the grid, the GCAC, the grid code advisory committee, grid code advisory committee. So it provides advice in that sense, but this one might work slightly different, or its scope is much broader than the GCAC, in the sense that, as I indicated during my presentation, Section 6 also allows the minister to step in and get some guidance and request the IMAF to do certain things. But before the minister does that, there will be a consultation process. So that's where it broadens now, that scope of the IMAF. And secondly, as it works in other countries, Australia, for instance, you will find that there are certain work streams or certain committees within the IMAF that are intended to advise appropriately. If, for instance, you've got expertise that pertain to economics of competition, you have them on board, then they will be paying much more attention on issues of discrimination. Yes, they will enhance the capacity of Nersa in that regard and help us also to do things right. But others also, because we've got the market represented there. They will also look into the technical issues, balancing issues that we're supposed to look at. So all of that will help Nersa, but also you expect interface with the market SAWEM and the market operator as well. So I hope that I have clarified insofar as the critical role of IMAF being a body that must advise Nersa, but now its functions are amplified in the law when it comes to the new legislation that was implemented since January of this year. I'm going to leave Chairperson, I've touched on those things. I think the rest, Chairperson, if you can come in and answer them. Thank you very much.
Thank you, Ms. Masetti. Ms. Masetti, I think the question that Ms. Carol Payton and Mr. Chris Yelland asked about the independence of Eskom is the one that maybe we need to deal with a little bit more decisively in this. The part around that, for as long as Eskom is the Eskom Holdings is the shareholder of the National Transmission Company, there will always be the perception that they can have influence. In fact, in what Ms. Yelland has even said, that would it be fine if the board of Eskom approves the market code before Nersa? Those are the questions that we must grapple with. But what we must never forget and always remember is that even though the Eskom board, let's take a case where the Eskom board would have to approve the market code, it is not the final word. The final word on the market code on what it would be the energy regulator. So they can approve all they like, but there would still be other parties that participate in the approval of the market code, and it will still be out there for public consultation. And the final word on the market code will be the energy regulator, not Eskom. And what we are trying to work out, as you had indicated, is to find a way of separating this. But having said that, I always want to come back to this. I mean, at the end of the day, we have the same shareholder. Us and Eskom, we have the same shareholder. But we have rules that have been put in place that make us to be able to make our decisions without any undue influence from any party. So that autonomy of our decision-making process is the one that would want to impose also in the National Transmission Company South Africa, the autonomy of their decision-making, not that what their shareholder is, who their shareholder is. And I trust that really that addresses that, yes, there may be that perception, but they are not the be-all and end-all of the market code. The energy regulator still has to approve. The energy regulator still will give parties an opportunity to present their facts and evidence on whatever market code is proposed by Eskom. The other question around that, whether the municipalities and Eskom distribution may add other conditions to the ones that were the rules that have been approved by the regulator are the only rules that must be applied. If there are other exceptional circumstances that have not been considered by the regulator in allocating the grid, it will still be the duty of the regulator to approve those exceptional circumstances. And I think the Act says that if there are objectively identifiable and distinguishable reasons, then the licensee must present that, but it must still be approved by the regulator. So we will still approve that. And on whether there will be more than one operator, part of the market code is also going to be dealing with that. Now, for the next 5 years, we are dealing with one market operator, but the Act does not preclude a situation where there is more than one market operator. But at least for the next 5 years, we are only going to be looking at one market operator. The other part around grid access rules and IPPs that connect IPPs, the issue around that, the IPPs that are arguing that once the once the power stations are no more functional, that grid should be put out there. And I think the jury is out on that. And for now, it has been assumed that because the ESCOM has those assets and because they have indicated in one or two areas that they would be putting up a plant, that's why they've been granted the access. But in cases where they are not going to be building anything, then that grid will then be given to the other parties that are able to connect and able to bring power. And at the date of SAWEM of April 26, I think set by the ministry, and I mean, it's a process that they are following, and I think that it's a date set as a target. And if we are not ready to start the market, if we do not have the market code, we do not have all of the things that are required to have the market, we probably would have to postpone the date of April 26. But for now, that's the date that's been set, and it is not controlled by Nersa. It is really controlled by the Department of Electricity and Energy. And I think Ms. Masetti has addressed the part around the IMAF. If it is just looking at the market operator, I think it would look at the market and the competitive electricity market in general that we are supposed to put up. And the question around the wholesale tariffs, at what stage are we on? We have not got there yet. We are still working on the different components of what that wholesale tariff would be. And as Ms. Masetti has mentioned, there are still issues around what should constitute the fixed cost, what should be considered the system marginal price, which would be sale price. It is still work under construction because there are certain areas that other entities or other parties want to be excluded or included. And if they're excluded, that would also affect the wholesale price. And that wholesale price has to be at a level that ensures that we get the least possible price of electricity from the least production cost, but as well encourage investors to invest because they see that they can make the necessary returns in their investments. I think, Mr. Hlebela, we have covered all of the questions. And the question by Lamiz was that whether the vesting contracts have been provided. The vesting contracts have not been provided as yet. We are aware of what they would be, but they have not been formally submitted to the energy regulator. Thank you very much, Charles.
Now, thank you, Mr. Bugula and Ms. Masetti for the responses. I think we have covered all the questions asked. Let me just check if ever there are any follow-up questions or point of clarifications from the colleagues. Yes, Lamiz, can go ahead.
Hi, yeah, this is just an admin question. Will the grid access rules be gazetted? Or will it be published on the website? I just need to know where to find them.
Okay. Ms. Masetti?
Yes, they will be gazetted so that stakeholders can be able to access them. But I mean, they will also be in the Nersa website. So we will notify stakeholders where to find the rules themselves. So they will be gazetted and also they will be on the website. Thank you.
Thanks, Ms. Masetti. Colleagues, any other final question? Point of clarification? I don't see any hand. With no further questions, colleagues, we conclude today's media briefing. And I just would like to thank our panel members for their valuable insights, and you colleagues from the media for your thoughtful questions. And thank you all for attending this media briefing, and have a great day. Thank you.
Thank you, Charles. Thanks.